Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I am the Western Canada practice leader at St. American LLP, where we handle insurance claims including LTD, long-term disability, short-term disability, critical illness, and life insurance issues. So we welcome all questions which you can send via the social media platforms and send them now. So I'll respond as best as I am able to do so. One of the first things that I'm going to discuss today is the interplay between a workplace injury or a workplace claim and LTD and WCB. When you have coverage through your employer for long-term disability, and if you have a workplace injury for which you may be qualified to receive WCB benefits, the way this works is as follows. Long-term disability policies provide that there are certain offsets. In other words, certain things that can be deducted from the long-term disability benefit. One of those would be work-safe benefits. In other words, loss of income payments that you receive from WCB. So if you have a claim, let's say, for example, you're working in a heavy physical labor job, you're operating machinery, you fall off, you break your leg, you cannot work, you make a claim with both WCB and LTD. The LTD carrier will tell you that they may approve the claim, but they're not going to pay anything to you as long as WCB is being paid, because the WCB benefit is deductible from the LTD benefit, and WCB usually pays more than LTD. In other words, the LTD benefit will likely be wiped out by the offsets, which would be the WCB claim. Where this really becomes complicated is when the injury is a mental health injury. For example, bullying and harassment, which comes up quite often. We see a lot of these claims. As me, my team, and I speak to people with WCB related or LTD related claims where the disability arose as a result of workplace bullying and harassment or a toxic workplace environment. When a person makes the claim, they often feel that they have to go out of their way to prove how toxic the workplace was in order to convince the insurance company that they have to be paid. Now, the insurance company will say to you, if that is the case, if you do have a mental health illness that arose as a result of workplace bullying and harassment, and that's the only reason why you are disabled, that your claim likely lies with WCB or that it may be an employment issue. The reason for that is the disability policy provides that benefits are paid for a total disability that prevents you from engaging or performing the essential duties of your regular occupation. That is the key word, occupation, not job. So how this is interpreted is if you are disabled from performing the duties of your job because the workplace is so toxic, there are people there who make it very uncomfortable, who create anxiety for you, that may lead to panic attacks. You cannot work there. But if you were to be placed in a different location, a different branch, or even with a different employer, performing the exact same occupation, the toxic workplace is not there, the bullying is not there, the harassment is not there, you should be able to perform your duties. That's usually the position that insurance companies take, in my experience. And the claims are invariably denied because the insurance company will say to you, we accept that there may be these issues, but we're not looking at whether you're unable to perform the job where you are at with that employer. We're looking at whether you have a disability that would prevent you from performing the duties of your occupation in any setting for any employer. So if that happens, consider, does it mean that if you have this disability that has been created by the workplace, have there been other issues that have impacted your mental health outside of the workplace, which also negatively impair you? Or are you so impaired that even if you were not placed in that workplace, that you can still not go back to work because you first need to recover, you first need to go for treatment? If that is the case and your claim is denied, by all means, reach out to us. We do offer free consultations and we can review the denial letter, the medical information, the policy, and your personal circumstances with you. And we offer that on the basis of a free consultation. So as you can see on the screen, go to disabilityrights.ca for more information. If the situation is that you are so disabled that you cannot work in your own occupation versus your own job, this is where the doctors really do come in, where the doctor would then write a letter advising why it is that, regardless of it having it happened in that particular workplace, you are now unable to perform the duties of your occupation for any employer in any workplace, and detail the restrictions and limitations. Remember, a disability claim is much more focused on the functional restrictions and limitations, the functional impairment, than on the diagnosis itself. Of course, the diagnosis is important, but the most important thing would be, what are the restrictions and limitations? Lots of people have depression, yet they can work. So if you have depression and cannot work, you're going to have to flesh out, with the help of your family physician or some other treating doctor, to explain why it is that you, with this condition, cannot perform the essential duties of your occupation. And that would mean focusing on the diagnosis, focusing on your actual occupational duties. For example, if you work as a police officer and you now have PTSD, what are the restrictions and limitations? If you have panic attacks, social withdrawal, you cannot focus, you cannot concentrate, you've got poor memory, you've got low energy, poor motivation, cannot sleep. How does this impact you? And then conclude, based on all of those things, why the person cannot perform the duties of their occupation. That's usually what is required when you do submit a disability claim. And again, if your claim is denied, contact us so we can have a discussion with you about what your options are. One may be an appeal, but there may also be the option to pursue a legal claim. And what is extremely important is there are certain timelines that you have to abide by. Specifically, something called the limitation period, which would be the timeline within which you can pursue a legal claim. And it depends on what happened in your claim. Were you paid? Were you denied outright? Which province are you in order to assess when the limitation period begins to run. Anyway, there's a lot more to be said about that, but let's start with the questions. B. Burrow says, my sister suffers from fibromyalgia and has been struggling to get coverage. Is there something she could do to help ensure approve a claim? She's been off work for about 8 months now. There's something called subjective illnesses or subjective conditions. Another way of describing it would be an invisible illness or an invisible condition. Another one is subjective conditions. Unfortunately, fibromyalgia, chronic fatigue syndrome, chronic pain, when it's not detailed on or cannot be seen based on some compromise in the spine, all of these, and including mental health illnesses, are described as subjective conditions. In other words, it is based on self-report. It is based on what the person says they are experiencing. There's no objective X-ray, MRI, or CT scan that can necessarily identify, oh, there is the problem, this is why the condition is there. Fibromyalgia often is a diagnosis that is made by exclusion. So lots of people have fibromyalgia, lots of people file claims with fibromyalgia because they cannot work. It is a very real illness. It is a real condition that can be profoundly disabling. Many of these cases do get denied. First thing I would suggest to you, Rose, is have your sister contact us so we can discuss with her what her options are. And I would want to see what evidence has been submitted in support of the claim. Remember what I just said a few minutes ago with what the doctors would detail. Fibromyalgia is the diagnosis, but that's not the most important thing. What are the restrictions and limitations? For fibromyalgia, you may have chronic pain. You may have, in addition to that, IBS. You may have brain fog. You may have depression, anxiety, because often there's an interplay between those conditions. And the doctor would want to identify all of those and then detail all the restrictions and limitations. Have your sister referred to a rheumatologist if necessary, or a chronic pain clinic, depending on which province she is in, and detail what the treatment would be. Have the doctor speak about what treatment has been tried, whether it be Cymbalta or some other medication. Another word for it is duloxetine. These are generally what we see when you have a claim submitted for fibromyalgia. If doctor has done all of that and there is no resolution, in other words, the insurance company is not approving the claim, again, get a lawyer involved. I would strongly recommend, because then your sister doesn't have to deal with the insurance company. All communications go through the lawyer. But those are discussions that can be had if you do contact us, and we offer, as I said, a free consultation to explain to her what our options are. And if she decided to proceed with an appeal, which is her right, then she can decide and have a better informed, will be in an informed position to decide how she's going to do that and what information can be done. But in all these cases, all of them, the doctors form a very, very important role, play a very important role. The more regularly the people see the patients, the insureds see their doctors, the more helpful it will be to the doctor to provide an informed opinion as to what they observe independently, not just on what the person is reporting, but what do they observe and why do they believe that the person is unable to work based on the diagnoses and their restrictions and limitations. John B says, good day, Sanfurians American. With regards to the disability law, is this different from a company's disability from a government disability? Please and thank you. I'll try and explain this as I understand this question. Is there a difference in disability law between a company's disability, which I'm assuming would be through an employer's disability plan, which they may have with an insurance company? So in other words, if you are employed with an employer, or sometimes self-employed, and you purchase a policy, but let's speak about a group policy. You're working for a bank, for example. Through the bank, through your employment, you have benefit coverage, which would include long-term disability and sometimes short-term disability. That is paid generally by an insurance company. So you're paying monthly premiums in order to have that coverage. Government disability is broader because it may be provincial government or it may be federal government. Provincial government, if I were to speak, for example, about BC, there would be PWD benefits. In Alberta, it would be H. And then you get the federal benefits, which would be CPP disability. There, you have to prove that you cannot perform the duties of any occupation based on a condition, an injury or an illness, and that condition must be severe and prolonged to the extent that it prevents you from working in any gainful occupation. So there is a difference between them because the one is paid by government, the other one is paid by an insurance company. The one is deducted usually from the other, and it usually would be that the private insurance company would be deducting the payments from the federal government. That is what disability law is. So if we do get involved in cases, we look at all of this because the one interacts and interferes with the other one to some degree. I hope that answers your question. Sam Lou says, I've been on LTD for about 6 months and need to move in with family so I have more support. My family are in a different country. Will this impact my LTD payment? It's a good question. It's a difficult question, and you have to be very careful here. First thing that you need to know is what does your policy provide for? Some policies will provide that if you leave the country for beyond a certain minimum timeline, that the insurance company may suspend the benefits or may deny the claim or terminate the claim or suspend benefits, as I said. So the policy may say if for whatever reason you're out of the country for more than 90 days or 30 days, whatever it may say, the benefits are not paid unless you have the approval, I suppose, or the consent of the insurance company. Some policies are silent on that. And I've represented clients with both, where they were limited for a timeline and where there was no limitation. But that's not the only thing. Another thing that comes up regularly is if you were to leave the country. Sorry, I see somebody says the quality of the sound is not great. Let me see if I can do anything about that. If you were to leave the country, you would want to make sure that you continue to see doctors on a regular basis and that you attend regular treatment, follow treatment recommendations. Let's say that you did leave the country to go somewhere else and you're moving in with your family, as you say, and that the policy was silent on the fact that you could leave the country. In other words, there's no restriction on you leaving the country. Then you want to make sure that if you did do that, that you be under the regular care of a physician, really make sure that you do that, and follow through with recommended treatment options, so recommendations at least, so that you still abide by those obligations under the terms of your policy. So if you do have further questions on that, get a copy of the policy and you can contact us and we can review it with you. And again, go to disabilityrights.ca. You can see us on the screen for more information. There's a question on YouTube from Edmund. I've noticed a vehicle parked near my house and have also seen it frequently when I leave my home. Is it possible I'm being recorded by my insurer? If so, is there anything I should do? Are they allowed to do this and not tell me about it? This is a good question. Surveillance is conducted sometimes, not all the time, and it's impossible to say when it will be conducted. But in my experience, if insurance companies do conduct surveillance, it likely will not be more than a week or 2 weeks. It may just be for a few days, or it may be sporadic that they never do 3 days now, 3 days later, and then 2 days after that. Is it possible that the insurance company is doing that? Yes. If the car is parked outside of your house and you feel threatened by it, then of course you can contact the authorities. Are insurance companies allowed to conduct surveillance? Yes, they are, but there's limitations to this. I've had people ask me, can they bug my phone? Can they read my email? No, they cannot do any of those things. They can record you. They do require, I've seen ones where they have retained investigators, and the investigators have recorded the person as they leave their home, drop off their children, go to a fast food restaurant, go grocery shopping, go wherever they go, and then follow them around, even inside a store, specifically to see, and this is when it happens, if a person says, I have these difficulties, I cannot sit for long, I cannot drive, I cannot bend, I cannot pick up things, then the insurance company retains a private investigator and record people where they may be doing the things that they say they cannot do. Now, of course, there may be explanations for that. Another thing that is done quite often and is done regularly is online surveillance. Social media is a gold mine for insurance companies. So if you do have a claim and you have a Facebook account and an Instagram account and whatever other accounts, and you're very active, posting whatever it is that you're doing, the insurance company may get access to that through private investigators. So when you ask what is there that you could do about it with the surveillance, I don't think you can stop the insurance company from doing it unless it is encroaching on your privacy to the extent that it becomes uncomfortable and dangerous, and then you can report it to the authorities. But be consistent in what you report to the insurance company with respect to your restrictions and limitations. If you cannot do certain things and you've reported that to the insurance company, just keep with that. One thing that I would suggest, if you ever get questionnaires from the insurance company, in other words, a request to keep a daily log of activities for, say, a period of a month, that may be a sign that the insurance company is going to conduct surveillance. Because what they will do is, if you get that document and you complete what you do on a regular day, as the day goes by, they may be recording you as well while over the same time frame. Then they would check to see with what you reported on those activity logs, whether it would be consistent with what they observe in the surveillance. So if you do get a request to conduct activity logs, be careful. Obviously, you have to be honest. So complete them, but make sure, that you report accurately what your issues are, but also be wary that there may be surveillance that would follow. Ricky Pisani says, if an employer is found liable for a workplace injury resulting in a permanent disability, could one potentially sue for beyond the 2-year lost wages earning potential? Complicated case, much more to it. So, if it is a workplace injury, then I assume that your claim lies with WCB. If WCB has denied the claim, then yes, you may have, if you are unable to perform the duties of any other occupation, and you have a disability claim with a insurance company through your employer, your question is, can you sue for beyond the 2-year timeline, which I assume is you're asking, can you access benefits into the any occupation period other than just for the first 2 years of your own occupation period? If your doctor supports that you cannot work in another occupation, that your restrictions and limitations are such that you cannot work in an occupation for which you do have the transferable skills, and that would pay to you something equivalent to your long-term disability benefit, then yes, of course, if you do qualify for benefits under that definition, you should be able to pursue that. The complicated issue here is that there is a WCB claim in place. as I said earlier, WCB usually would be benefits you receive from WCB usually would be deducted or deductible from your LTD benefit. If it is complicated, Ricky, you're welcome to reach out to us if this is a claim against the insurance company versus WCB, and we'll be happy to have a discussion with you and to review your case and advise you at least what we believe your options would be. Oh, Merriman says, I have a question. I've been on loss of absence from my employer. I was told by my manager he took me out of the system for being off and had to hire someone in place until I'm back. Is that legal? Let me just quickly check. On Wednesday, which is tomorrow, 1 p.m. Eastern Standard Time, 4 p.m. Pacific Standard Time, there will be an employment session with my partner, Willemse. So the fact that you're away and the employer has replaced you with somebody else, at least, and they're taking you out of the system, is that legal? That is an employment question. So please log in tomorrow at 1 p.m. Eastern Standard Time, and you can put that question to legal, and we'll be able to answer you. Lee says, what can an employee if their doctor is not supportive? I suppose what can an employee do if their doctor is not supportive? Is a psychologist letter enough to get LTD, or is a family doctor mandatory? What about a nurse practitioner as an alternative? Thank you. Lee, this is a great question, and it comes up regularly. So, firstly, if your doctor is not supportive, I would suggest that you continue to see your doctor on a regular basis, or if I'm understanding this correctly, you're seeing a psychologist as well and potentially a nurse practitioner. In the world that we live in this country, as we all know, there is a huge shortage of doctors. Lots of people that I speak with are being seen by nurse practitioners. On the other hand, you have a disability policy that requires that you be under the regular care of a physician. A physician is usually defined as somebody who is basically a family doctor or a specialist to that degree, but often that is simply not practical. When you submit a disability claim, in other words, if you do not have the support of a doctor, but you may have the support of a psychologist or a nurse practitioner, yes, by all means, get them to write you supportive letters, get them to explain why it is that you cannot work. I'm assuming from what I'm reading that this is a mental health illness because you're seeing a psychologist. And there may be reasons why your doctor is not supportive. Your doctor may be overworked. Your doctor may not have seen you enough. So if that is the case, try and get in to see your doctor more regularly. If there is an issue between you and your doctor, you may want to look elsewhere for treatment. But, I cannot say whether the insurance company is going to approve your claim. Is it mandatory to have a family doctor? Under the policies, they do require that you see a physician on a regular basis. But as I've said, in the real world, that just is not practical all the time. So I do see people who do not have family doctors, even people who go and see walk-in clinic doctors because they struggle to find a family doctor. You cannot force that situation. If there is no family doctor available, that just is how it is. So get whatever supportive evidence that you can, submit it, and if it is denied, or if you want to have a further discussion about this, again, reach out to us. As I've said, we offer free consultations and we can guide you through the process and advise you what your options would be if you were to be denied. As you can see on the screen, disabilityrights.ca is the place to go. Kelsey Corrin says, I've been with the company for 7 years and they just restructured and fired 75% of my team. I've previously been dealing with mental health illness and now I'm extremely stressed. I worried if I disclose my illness, I will be fired. Can they offer me a severance if I disclose my illness, or is this a protected ground? This, again, is an employment question, Kelsey. So I strongly recommend that tomorrow during the employment law Q&A, which is at September the 4th, which is Wednesday tomorrow, at 1 p.m. Eastern Standard Time, as you can see on the screen, you can pose that question to my partner, Willemse. Ricky says, follow-up, was on modified duties, LTD denied, and settled with insurer. Employer frustrated at my contract and dismissed me without severance. Mediation is pending. CPP was approved. How does this impact my case? Well, if you settled with the insurance company already and your LTD claim was denied, it sounds like that there are issues with the employer. And I would recommend that if that is the case, like with the previous question, speak to an employment lawyer. You can post some of these questions to Lior Samfiru tomorrow at 1 p.m. Eastern Standard Time, because at our end, we handle long-term disability claims. And if your LTD claim was already settled, then unfortunately it's not something that I can assist with. Question on Reddit from Lorax. Can a pregnancy impact my LTD? Would receiving a baby bonus or other money for a child change my payments at all? It depends on the wording of your policy. If you are receiving maternity EI benefits, it might be that your policy would say that benefits are suspended for any period that you do receive maternal benefits from the government through EI. It really depends on the policy. So if you can get a copy of the policy, we can review it with you. But that's generally the sense that if there is benefits being received for a period of time for that, your benefits with the insurance company might be suspended. Would receiving a baby bonus or other money for a child change my payments at all? It depends on the language of your policy. I'm not sure what a baby bonus would be, but if the policy provides for payments being deducted from the government or from the employer, it depends, because not every policy has the same wording and provides for the same offset. So if you do have the policy, we can review it with you. Question on YouTube from Will. My mom applied for short-term disability for health reasons. Her employer terminated her, I suppose, while she waited to be approved for disability. After my mom passed it, disability was approved and retroactive prior to her termination. What do I do? I think, well, this is something that you should probably reach out to us and we can have that discussion with you, because I would want to know a little bit more about this. Payments were approved for the period until she passed. That I think that period should at least be paid, but I would want to get further information. Sam Lou says, thank you, I really appreciate your help. I will have to talk to my insurer. My impairment is due to a brain injury. It does not affect mobility so much, so the journey wouldn't be a problem. But you want to make sure that you have a copy of the policy and to review it. So if the impairment is due to a brain injury and it does not affect your mobility so much, the journey wouldn't be a problem. It's not just the fact of the travel, it's does the policy allow you to be outside of the country in the first place? And if it does, or if there's no restriction, you want to make sure that you see the doctors regularly. The insurance company is not going to like this fact. I can tell you that now. So they want to be able to monitor the medical information. They want to make sure that they can get updates from your doctors, etc. So it's going to be a difficult situation to manage, I believe. But get a copy of the policy. Question from Selena on YouTube. I have been waiting 6 months for my LTD application to be processed. Is this a normal amount of time to be waiting? Is there anything I can do to speed this up? Unfortunately, Selena, it really is all over the board. Sometimes the decisions are made quicker, other times they are not. From my perspective, I would say that the insurance company has a duty to treat you in good faith. And that means to make a timely decision on a claim. If you submitted all the necessary information, there really should not be a 6-month delay. There shouldn't be. So I would, if I were you, escalate this to because you would have a case manager. Put the case manager on notice that, and put everything in writing. This is when you submitted the claim. These are the updates that you've received. You have not received money for 6 months. This is impacting your disability, if it is. It's impacting your mental health. The stress added by this is not conducive to any recovery. If there's no response, escalate it to the manager and beyond. Be the squeaky wheel, because it should not be taking this long. It really shouldn't. And I've seen cases where it took so long that the person, because they could have accessed some better treatment as well if they had received the funds. But because they didn't, their condition became worse and the recovery took so much longer. So that would be put on the insurance company if they're not approving the claim or making a decision at least. If you did, and this is important, if you did submit all the necessary information. So be the squeaky wheel, put pressure on them, escalate it to the manager and the manager's manager if you need to. So that was A lot of questions today. Thank you so much for everybody reaching out to us. If you've got more questions, go to disabilityrights.ca and you're welcome to reach out to our team. Again, we offer free consultations where we will review your denial, if there is a denial, the policy, if you do have it, your medical information, and discuss with you your circumstances in order to provide you your options and you can make an informed opinion. Join again tomorrow live, which is September the 4th, goodness. 1 p.m. Eastern Standard Time with Leor Sanfira, my partner on all things employment law. Thank you for joining us and have a great week.